much. First, I would like to express my gratitude to the Central European Academy for involving me in this research project and to have the opportunity to work with so many professors of high level in this international research project. My topic of research in the book is connected to the conditionality mechanism, so I will talk about how the rule of law appears in the conditionality mechanism, and also I will share some reflections with regards to its practical application. So first of all, how does conditionality appear in EU law? It is not a unique concept, it's not foreign to European law at all. First, it started to appear in the European Union's external policy, especially to third states in connection with trade and humanitarian aid. This was developed primarily in the 90s, but it also appeared in the 80s. Some examples are the Lomé IV Convention and the most recent commercial trade agreement with Canada. So what happened is that the EU insisted on the human rights clause in these trade agreements, and actually Canada didn't really understand why it was necessary, given that Canada has a high level of respect for human rights. Nevertheless, the European Parliament wanted to show an example and to say that it is indeed important for trade agreements to include some sort of human rights conditionality. Another type of conditionality appears in the EU enlargement project. This is primarily expressed by the Copenhagen criteria developed in the 90s again. So, of course, the EU developed certain criteria, certain conditionality to join the European Union for other European states wishing to join. As for the internal policy, we can also find some examples of conditionality, primarily in the financial sector. So the first one appeared in 1994, the macroeconomic conditionality in connection with Greece, Portugal, and most recently the multi-annual financial framework of 2014 and 2020. It introduced ex ante and ex post macroeconomic conditionality. The newest one from 2021 to 2027 introduced even more emphasis on the rule of law as a precondition for the receipt of EU funds. It can also be found in academic texts why it was necessary to apply a sort of rule of law conditionality to receiving EU funds. And that's how the conditionality regulation comes in the picture. A few words about the legislative history of the regulation itself. So it was first proposed by the Commission in 2018 by a proposal for the regulation on the protection of the Union's budget in case of generalized deficiencies as regards the rule of law. And in the end, we can see that it wasn't called as generalized deficiencies, but a general regime of conditionality. In the meantime, several institutions expressed their opinions: the European Committee of the Regions, the Court of Auditors, the Economic and Social Committee. And during the first reading, the European Parliament, the Council of the EU, and the European Commission, especially the European Parliament's recommendations in the first reading are remarkable. Not many of them were actually taken into account in the final version of the adopted regulation. The regulation itself was adopted on the 16th of December in 2020, and it is called a general regime of conditionality for the protection of the Union budget. So it is not a rule of law procedure as such, but it is indirectly connected to the rule of law. It is primarily a financial mechanism that is strongly based on the rule of law. I will follow the three pillars of the research. So I will first talk about the interpretation of the rule of law in the mechanism, and then the procedure itself, and then the sanctions. As for the interpretation, the regulation in Article 2A refers to the definition of the rule of law. What should we understand by the rule of law in the sense of the regulation? Of course, it refers to Article 2 TEU. However, as we know, Article 2 doesn't define the rule of law as such. It lists the values upon which the Union is based, other values such as human dignity, freedom, etc. However, the regulation itself gives a sort of understanding of the rule of law. Namely, these are the principle of legality, legal certainty, prohibition of arbitrariness, effective judicial protection, separation of power, and non-discrimination and equality before the law. Where was this list actually taken from? Primarily, it is based on the practice of the CJEU, but it was collected in a commission report. This one, which I put here, it's the one that called for the establishment of the rule of law framework in 2014. It is remarkable. So it was actually the first time that the Commission itself gave an understanding of what they understand by the rule of law. And until then, it was certain decisions of the CJEU which defined certain aspects of the rule of law, but not in a comprehensive way. Now we come to the problematic part. So what is actually the problem with the interpretation of the rule of law under the conditionality regulation? First, I have referred to the fact that the proposal of the Commission, so the initial draft regulation, defined a generalized deficiency, which does not appear as such in the regulation. Generalized deficiency implies more systemic breaches of the rule of law, so systemic problems, while the regulation itself introduces also that individual breaches of the rule of law might also lead to the triggering of the conditionality mechanism. And this is not merely a shift of a change of words, but it also implies a sort of shift of the focus of the mechanism compared to the initial plan. So it's still a question whether individual breaches could trigger the conditionality regulation or only systemic problems. As for the Article 2 TEU, of course, we know that it is primarily based on the case law of the CJEU. However, the rule of law itself wasn't developed by the Union, but it was first developed by the member states, and each member state had a different understanding of the rule of law. So, of course, the core values might be similar or might be the same in the member states, but different constitutional interpretation might focus on different aspects of the rule of law. So I put here a few examples: the État de droit, Rechtsstaat, rule of law, or even the Hungarian jogállamiság can have a different per se understanding of the rule of law. And how to harmonize them? The EU actually doesn't really take into account that the rule of law was developed at the member state level and then it was raised to the Union level. So it is not an autonomous concept of the European Union, but it comes from the member states' practice. And I have referred to the rule of law framework of 2014, developed by the Commission, which operates with vague concepts. So as we can see here, the list, I think it's really hard to determine whether there was an individual breach or a systemic breach of legal certainty, how to determine what is the threshold, whether there is legal certainty in an EU country or not. And that was just one example. And also, given that it's very hard to define the concept of the rule of law, the breaches thereof, it's equally hard to define. Even though the regulation itself gives an exemplificative list of what could be considered breaches of the rule of law, but I think it might have issues with legal certainty, that it's not consistent, and I think that it's a bit problematic for this sense. As for the control mechanism, so we come to the procedural part. It is set out in Article 3 of the conditionality regulation. So when the Commission finds that it has reasonable grounds to consider that the conditions to trigger the mechanism are fulfilled, then it sends a written notification to the member state concerned, who shall provide the required information and make observations. If the Commission considers that the remedial measures do not adequately address the Commission's notification, then it shall submit a proposal for an implementing decision on the measures to the Council. And then the Council acts by a qualified majority. Major recommendations were proposed by the European Parliament in the first reading of the legislative procedure, as I have mentioned, mainly giving a more involvement, more emphasized involvement of the European Parliament in the procedure, but in the final text of the regulation it wasn't really considered. Mainly the Commission must inform the European Parliament, but the Parliament doesn't have a major role in this procedure. And also it was criticized by the opinions of the Court of Auditors, for example, that the European Commission has a wide discretionary power in determining the breaches of the rule of law and whether to trigger the mechanism or not. In any case, both the draft proposal and the explanatory memorandum of the regulation set out that other procedures under Union law to protect the EU budget more effectively has to be considered. What actually happened in the proposal for implementation, so when the Commission triggered the mechanism in connection with Hungary, they didn't really evaluate other procedures. They just stated that it wasn't, other procedures are not really adequate in this sense to tackle the problems. However, also the question of effectivity of the conditionality mechanism arises because, as we could see, it is a new mechanism, so it was adopted in 2020, and the procedure, the only procedure so far, has not finished yet, so we don't know the results and the effectivity and the success of this mechanism yet. And I have touched upon the fact that the conditionality mechanism is not a rule of law procedure as such, yet the rule of law has a very important role in this mechanism. And the question arises whether the rule of law has some connection to a financial mechanism, and what connection and how. Because this regulation does not aim to restore the rule of law, does not aim to address the situation of the rule of law. It merely uses the rule of law situation in a given country for financial purposes, to address the protection of the EU budget. The biggest problem, in my opinion, here, in connection with the procedure, arises in connection with the simultaneous application of different rule of law mechanisms, procedures at the same time. So, for example, the Article 7 procedure at the same time with the conditionality mechanism. There was a CG-EU proceeding initiated by Hungary, in which Hungary claimed that the clear risk of a serious breach of the rule of law, or generally the principles or the values of Article 2 TEU, can only be determined in the Article 7 procedure. And without that determination, because that procedure is also ongoing at the moment, how is it possible to trigger another mechanism to say that there is a clear risk of a serious breach without the finalization of the Article 7 procedure? The CGU answered that it is not a problem and that the EU legislator may establish other procedures in connection with the protection of the values set out in Article 2 TEU, provided that they have different aims and different subject matter. And the court said that given that this is not a rule of law procedure as such, but it's a financial procedure, it is absolutely acceptable to trigger this mechanism also at the same time. Another question is the subsidiarity of the procedure that was also emphasized during the legislative procedure. And this leads back to the first question, the consideration of other procedures under Union law to protect the EU budget, and how this subsidiarity appears. Subsidiary to what, actually? Subsidiary to the Article 7 procedure, or subsidiary to other financial procedures that were not triggered? And as a last point, we can also see somehow the power struggle between the different institutions, especially between the European Parliament and the European Commission in this regard. So, as I have referred to it, the different opinion makers, so the Court of Auditors and the Committee of the Regions, also emphasize that the Commission has too much discretion in this procedure, and it is almost entirely up to the Commission to trigger this mechanism, to decide the breaches of the rule of law and to decide to launch the procedure itself. And on the other hand, we can see that in the Article 7 procedure, the Commission also has an important part from the side of the rule of law framework. So in connection with Poland, it was initiated, the Article 7 procedure was initiated by the Commission after the rule of law framework, and in case of Hungary, it was initiated by the European Parliament. And then the conditionality mechanism was triggered by the European Commission in connection with Hungary again. So we can see a sort of dynamics between the different institutions. As for the third part, the sanctions, they are also defined in the regulation in Article 5, which is interesting from the point of view that when you see the text of the regulation, first the regulation defines the breaches, so it gives some examples of what could be considered as the breaches of the rule of law. And then it defines the sanctions, and after it the procedure, which is, I think, a bit interesting. Why is there what is the logic behind it? Why to put the sanctions first and then the procedure? I think it would be more logical to put the procedure first and then to see at the end of this procedure certain sanctions might be envisaged but might not. But in this case, sanctions and then procedure, like it is necessary to support the sanctions somehow. The regulation defines two sorts of categories of sanctions. So one is where the Commission implements the union budget in direct or indirect management, and then the government is the beneficiary, the recipient. And in the second case, where the Commission implements the union budget under shared management with the member state. I'm not going to read all the sanctions. The main sanctions are the suspension of payments, the prohibition on entering into new legal commitments, or reduction of economic advantage, or also prohibition on entering into new agreements on loans and other instruments. And this goes also, something similar goes for the second category of benefits. The regulation requires the sanctions to be proportionate and to be non-discriminatory in nature, with a special emphasis on the protection of the final beneficiaries, because the regulation provides that the final beneficiaries may not be harmed in that sense that the government has to fulfill its obligations, even though it might not receive the funds necessary. What is particularly interesting here is that we can find in the draft proposal of the regulation that was submitted by the Commission, in the preamble, that it makes explicit reference to the final beneficiaries, so Erasmus students and researchers and civil society organizations. And this part just disappeared from the final regulation without any explanation. So the preamble of the regulation, of the adopted regulation, states that the final beneficiary's interest should also be taken into consideration for making the sanctions. In my opinion, it's a bit interesting why there isn't more emphasis on the protection of the final beneficiaries, given that they have nothing to do with the rule of law situation in the given country. As a second point, the Court of Auditors and the Committee of the Regions also emphasize in the legislative procedure that there has to be an impact assessment on the national budget, because we are talking about a huge amount of money and the provisional suspension of a huge amount of EU funds to the member state. And in fact, in this proposal for implementation that the Commission submitted to the Council in connection with Hungary, there was no impact assessment made on the national budget. And it might also be somehow against the interest of the final beneficiaries if we are thinking about the beneficiaries that I have mentioned before, the students, researchers, civil society organizations, etc. In this slide, it is interesting that in this proposal for implementation, so when the Commission triggered the procedure, it stated that it is not possible to quantify the significant potential impact on the identified breaches on the Union budget. So the question again arises how much it is proportionate and how much it is non-discriminatory to the member states. And we arrived to the conclusion. So it is very early to jump into conclusions in connection with the conditionality mechanism as such, because the procedure has not finished yet. However, what seems to be sure now is that it fits in the scope of the process of the supranationalization of the rule of law at the European Union level, because it is, as we could see, it's primarily a financial mechanism, and it has a strong emphasis on the question of the rule of law. It is not clear what is its relation to other rule of law procedures, especially to the Article 7 procedure, because the Commission didn't wait for the final result of the Article 7 procedure in practice in connection with Hungary, but it triggered the mechanism immediately. We can also see that it's also a tool in the power struggle of the EU institutions, particularly between the Parliament and the Commission. So I have mentioned that the EP has a major role in promoting the rule of law, especially in Article 7 procedure, in the experience of Hungary, which was launched by the European Parliament in the case of Hungary. And on the other hand, the Commission has a wide discretion in connection with the conditionality mechanism. So we can see again the power struggle between these institutions on this example. However, the question arises whether this leads to inconsistent practice or not. We will see, because as I said, it's too early to assess, but this question has to be answered in the near future when we will see the results. So thank you very much for your attention.